matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, Counselor, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
What? This is what he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get this. It's not the prosecutor.
Well, the first thing I want. Okay,
You want a trial today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they send me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial?
Well, let's see what the discovery evidence has to say. But first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say, can you
send this to the assignment clerk, Mr. Lanto, you're not listening. See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No. You're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts and nobody has said I'm talking crazy.
Oh, yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And then number two,
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? Is that, I'm asking a simple logical question. It's either yes or no. The proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time. And your attorney will be here in person, and we can talk about it. So when you get that letter,
well,
can I put on there that he's in person? I'm gonna indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
Well, I feel like
Exactly.
I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
would
thing I
you
could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me and then you said I'm talking crazy?
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
No, you said it in reverse. I said first that you're talking some crazy talk. Then I said I'm going to adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days.
This courtroom exchange quickly turned into a clash between internet legal theories and real courtroom procedure. From the very beginning, the judge was trying to keep the hearing simple. Either grant the defense attorney's request for a 30-day adjournment or move directly toward trial. But instead of answering straightforward questions, the defendant kept demanding what he called factual evidence of jurisdiction, insisting that a single document would somehow determine whether the court had authority over him. The judge clearly viewed the argument as nonsense, repeatedly warning the defendant that he was talking crazy and needed to start listening to his attorney instead of trying to argue legal concepts he didn't fully understand. What made the moment especially tense was how calm yet frustrated the judge became as the defendant continued interrupting and refusing to move on. As the hearing continued, it became obvious that the judge was losing patience with the endless back and forth. Every time the court tried to explain the process, the defendant circled back to the same argument about jurisdiction, claiming it was just a simple logical question. But in reality, the judge had already made the decision. The case would be delayed for 30 days so discovery could be completed. Instead of accepting that, the defendant kept trying to debate the court, which only made things worse. The judge even warned him directly that his habit of constantly talking and refusing to listen was exactly why he kept getting himself into trouble. It was one of those moments where you could almost see the disconnect happening in real time. The defendant believed he was exposing some legal loophole, while the court saw someone refusing to follow basic courtroom procedure. Then came the strangest moment of the hearing. When the judge ordered the defendant to appear in person next time, the defendant suddenly claimed he would feel in danger coming to court. The judge responded with obvious sarcasm, saying he would assign a police officer to watch over him. But instead of recognizing the joke, the defendant became even more alarmed. The conversation spiraled into confusion as he tried to replay the judge's statements back word for word, questioning whether he had been threatened or insulted. By the end, the judge had completely lost interest in debating and simply shut the conversation down, telling him to appear in person in 30 days and let his attorney handle the case. In the end, this hearing became another example of how courtroom proceedings can completely derail when someone relies more on internet legal theories than actual legal advice. While the defendant thought he was asking intelligent questions, the judge saw someone refusing to listen, refusing to cooperate, and making his own situation far more difficult than it needed to be.